So apparently I didn't have my microphone on. Thank you for being here. We're going to get started in just a moment. If you would like to download the course materials, sorry for that. This is my first time running the webinar. I'm getting used to the controls. Welcome to the webinar for young marrieds. My name is Rob Wolfgang. I'm an attorney, Bard in Maryland. I'm an associate here at Chesapeake Legal Counsel. I've been working with John since 2018. I'm 37 going on 38, and I am married with 2 children, so this webinar is right up my alley. I hope you like it. We have a handout section in your dashboard that contains the PowerPoint and also a PDF of the PowerPoint where you can take notes. If you have a question, please click on the little hand. There's a little hand in the upper right-hand corner where you can ask questions. Please ask questions during this webinar. It'll make it more interactive. And here we go. Welcome to the study of wills for young married people, sponsored by Chesapeake Legal Counsel. For those of you that are not familiar with the webinar, welcome to the world of high-tech learning. Although you can hear me, I cannot hear you, so please use that little hand in the upper right-hand corner to ask questions. When you click on the hand, you'll see a little box where you can type in the questions. Or if you prefer, or if you're watching this as a recording, you can always send your questions to our office at info@robertlaw.com. That's info@ROBBERTLAW.com. 2 B's in Robert. And on the screen now, you can see our address. We have an office in Annapolis and Ocean View, and our website. Please check out the website. We post our recordings to our website if you need to review the materials after this webinar. So today we're going to explore the ways in which you can plan for your spouse and your children if the worst happens way too soon. So here's the issue. You probably have a large term life insurance policy in case both you or your spouse die. Who gets to spend that insurance money? Even worse, who gets to raise the kids if both you and your spouse die? The point of today's webinar is to encourage you to decide now who will spend the money, how it will be spent, and who will raise the kids and how they will be raised. And once those decisions are made, we're going to incorporate those decisions into a will. Wills for a young couple are different from wills for older people because of the extra planning necessary for the children. A well thought out will done now for a young couple can last well into old age. But to contrast, a simple will, what lawyers call an I love you will, that says, if I die, I leave all to my dear wife, and if she's deceased, then all to my children. A will like that works for older clients, but not for young ones because of the special planning considerations necessary if you have young children to worry about. So let's get started about talking about what's at stake, what's on the table. So take out your pencil and paper and make a quick tally for yourself. No, really, I'll wait. Jot down some quick numbers just to get an idea of how much is at stake in your estate. Some of these assets you will have 2 of due to being a couple, like IRAs, 401ks, and life insurance policies. At the beginning of this presentation, we asked the question, if you and your spouse are deceased, who gets to decide how the money is spent? Look at the total of your assets from the previous slide, including life insurance proceeds, and now picture all that wealth in the hands of a teenage child. Without a will, a person turning 18 gets unsupervised control of these assets. We've had a lot of clients tell us that their children are not like that, even though their child's still only 4 years old, or that their children are frugal. Maybe so, but What about your children's friends, say a boyfriend or a girlfriend, or other influencers? I mean, we've all heard about this new job called social influencer. The next issue was who raises the kids. More importantly than controlling the assets is who controls the children. Who decides where they live, what school they go to, whether they can get a tattoo or buy a motorcycle. Could be prissy old Aunt Bessie from the old school that believes children should be seen and not heard. Or it could be your brother, the free spirit who believes that children should be given the freedom to express themselves. These are two extremes, admittedly, or maybe not, depending on how you see your spouse's family. But the point is, if you have a family, your spouse has a family, and choosing one side or the other to raise your children has consequences. Think about it. This can only be an issue if you and your spouse are deceased. But if you have not made any decisions, it is not unusual at all for both families, especially both sets of grandparents, to believe that they are the best suited to raise your children. That is when the litigation starts, what is commonly called a custody battle. It's like a tug of war with your children are roped in the middle. Absolutely, the most important reason to have a will at this stage of your life is to not put your children in a position of having to express a preference to live with one grandparent or another. It's a recipe for hard feelings that can scar a child for the rest of his days. We're going to do a pop quiz. So you're going to see a pop quiz question pop up here on your computer screen. Please go ahead and click the option that you find to be the best answer. The question is, coming up, there you go. What is the reason that most young people don't have a will yet? So go ahead and take a few moments and answer that pop quiz. Take your time, and while you're doing that, a question came in. Let me see what that is. Okay. Does the person raising the child also have to be the same person controlling the money? No, and we recommend that they be different. One protects the purse and the other protects the person. This also eliminates potential conflict between your child and his or her custodian. I mean, for instance, this conversation is not unheard of. Uncle Bill, I want money for a tattoo and a motorcycle. No. Uncle Bill, whose money is it? Is adding a bedroom or bathroom for your benefit or the child's benefit? Okay, let's take a look at the results. Right now, we have the top two answers are equally split. I don't consider it important, and I don't have time to deal with it. All right, let's get off this scary clown slide. So let's sum up the issues that we've talked about so far. So both you and your spouse have passed away. If you do not have wills, your assets, like your home equity savings, life insurance proceeds, will be in the unsupervised control of your 18-year-old. Even if they're under 18 when you pass, they will get control of those assets when they turn 18. Speaking of underage children, if you do not have wills when you both pass, the court ultimately decides who will be the guardian for your children. It is unlikely that both sets of grandparents will believe that, it is highly likely that both sets of grandparents will believe that they're the best suited to be the guardian of your children. A custody battle can ensue, and placing the children in the middle of a tug of war. So the courts are the one who decides that custody battle. But if you do have wills when you pass, you have made the decisions for yourself. Your wills can dictate who you want to receive your assets, your home equity, savings, life insurance proceeds, etc., and how they can receive them. Your wills can also dictate who you want to raise your children and even give those persons some instructions for how you want them to be raised. So I'm not saying that it's definitely the case that both of you are going to die at the same time, but to be honest, what are the real chances of you and your spouse both dying while your children are still young? Not so great, and yet we do see that. In fact, we had a case in this office like that just a couple of months ago. It reminds me of a Mother Goose rhyme. There was a little girl who had a little curl right in the middle of her forehead. When she was good, she was very, very good. And when she was bad, she was horrid. You may never need to use your first will, but if you have to, you really, really need it. You buy all sorts of insurance now for things that may never happen, like auto insurance, health insurance, home insurance, and life insurance. This is just another insurance policy just in case. All that said, I do not want to give you the impression that the only reason to have a will is just in case both spouses pass away. Even if one of you survives, there are still legal consequences to dying without a will. So this is what we call a bucket of assets, and you see there, if one of you was to pass before the other, joint assets such as your checking, savings, and autos, as well as assets with beneficiary designations such as your IRA, 401k, and life insurance will, in a normal sweetheart, I love you situation, pass upon your death to your spouse by operation of law outside of probate. They will automatically belong to your spouse. Assets owned in your name only, not jointly titled, will be subject to probate. Looking at the list of assets from earlier in the webinar, these assets would likely be any business interest of personal property or even an inheritance in some cases. These probate assets are the ones that will be distributed according to your will if you have one. So to show you why having a will is important, the Register of Wills, if you don't have a will, decides where your assets go when you pass away. In Maryland, if you do not have a will, the Register of Wills will distribute your probate assets 50% to your spouse and 50% to your children. If your child is over 18, they receive those funds or even your business interest without supervision. And in Delaware, if you do not have a will when you die, your spouse receives the first $50,000 of your estate, of your probate assets, and 50% of the rest of your assets. Your children receive the other 50% of your probate assets after your spouse takes the first $50,000. Again, you don't want an 18-year-old having control of your assets like that. When your child is under 18, the court will appoint a guardian of their person, which is the person to take care of them, and a guardian of their property, and that's the assets that pass to them. When the court appoints a guardian of the property, they don't want the guardian to have unfettered access to that property, meaning the cash that's supposed to be the child's. So they create restricted bank accounts, such as a UTMA account, a regular restricted bank account that requires a court order. And if it's under $5,000 that the child's going to receive, they will give that right to the guardian, but the guardian has a fiduciary responsibility, a responsibility that they can be sued on to spend that money for the child's benefit. So in the situation where one of you passes first and there's a surviving spouse, this chart is going to show you how we would recommend that we write a will. And I'm going to go discuss each little piece and tell you why we recommend this. This is the general case. Wills are highly personal. We can edit them any way that you prefer, and we customize them to your situation. So the first one of you has passed away. That person has a will. So in that will, we want to write in a testamentary, meaning something that comes into existence after you pass away, a family trust. Now, the purpose of that family trust is to hold the life insurance proceeds. Theoretically, you're going to have a large life insurance policy, but you don't want that going directly to your children. Now, it could go to your spouse, but if you put it if we create a family trust and we change your beneficiary of your life insurance to be the family trust created at your death, then those life insurance proceeds are protected from your spouse's predators and creditors. But we also want it to be available to your spouse, so your spouse will be the trustee and a beneficiary of that trust. Your will still give whatever you want, your probate assets to your spouse, but if your spouse was to go before you, then we will write into your will that it would go to your children in a trust. Now that way you can nominate who you want to handle the money for your children. And you can tell the trustee when you design the trust in your will at what age you want the children to be able to control those assets. So you can say at 25 instead of 18. So they've graduated college and they've got a few years under their belt where the trustee has been using that money for their benefit. So just because the money's held in trust doesn't mean it's unavailable to your spouse or to your children. It just means that there's someone to manage it for them. In that case, in the case where you are the second to die, we would change your beneficiary, suggest that you change your beneficiary designations on your IRA and 401k. The primary beneficiary to be your spouse in case they survive you, but in case they do not survive you, the contingent beneficiary, we would want to make that your descendants the trust in your will for your children who are your descendants. That way, that large IRA or 401k, the proceeds from that are managed for your 18-year-old. Or if they're under 18, they're managed by the person that you want to manage them. So that's at the first death is what this situation outlines. Again, if you have any questions, please submit them on the dashboard. So then we have a second death. On the second death, so the first person has passed away. With their will, we created a family trust, and we gave some portion of the assets to the survivor. So then at the second death, the family trust and the assets that are distributed through the survivor's will will flow through to your children. So again, they're going to flow through into a trust for your children up until the age that you dictate when you write your will. But it also gives us a time to write a contingent special needs trust. If you have a child who could potentially qualify for governmental benefits such as Social Security disability or Social Security insurance, you don't want that child to receive a large inheritance and be disqualified for the governmental benefits. So we include in all of our documents a contingent special needs trust. That way, if there is such a child, their inheritance will be held in a special needs trust for their benefit without disqualifying them for the program that they're currently enrolled in. But another reason that we should recommend that inheritance for your descendants, your children, should go into a trust is that if they receive the inheritance in a trust, that trust can also protect the assets from your child's divorce, creditors and creditors, bankruptcy, and estate taxes. So we rarely recommend that you distribute anything directly. Most of the time, going into a trust is the best option. So whenever we do estate planning, we also, the estate planning includes wills or trusts and also new powers of attorney. We create a general financial power of attorney, a durable financial power of attorney, and a durable healthcare power of attorney. So when is the best time to create a healthcare proxy? All of these situations, it's always the best time to create a healthcare proxy. You want someone to be able to make a healthcare decision for you in case you cannot. You never know when you're going to have an accident, you're going to be unconscious or unable to make a decision, and you don't always want the hospital to make that decision for you. You want your loved one to make that decision for you. So if you're in the middle of a crisis, go ahead and make that healthcare proxy, the healthcare power of attorney. If maybe later that's not the best option, you never know when the accident's going to happen. It's better to have it in place just in case. And you can make powers of attorney anytime after the age of 18, but really now is the best time to make a healthcare proxy. So let's do another survey. What was the most important thing that you learned or realized today? If you do not see a response to the survey that you like, remember that you can always send us an email to the office, info@robertlaw.com, info@robbertlaw.com, 2 B's in Robert. And while you're answering the poll, we did have another question come in. Can you have 2 people play one role? Can 2 people be joint trustees for the money or joint guardians? For example, should I name my sister and her husband? That type of situation is not recommended. Just name one of them, name your sister. We always suggest a successor for all appointments. So I appoint my sister, but if she cannot do it, then make the husband the successor. If you're going to have joint trustees or joint guardians, who's to say that sister and husband don't get divorced and now they're still joint guardians of your children and have to make decisions together? Now we have to get the court to separate them from being guardians. It's also really hard to get 2 people to always agree. So we recommend having one person fill a role and then having a successor. Okay, so let's check out the results. It looks like 2/3 of you said all of the above. You should start working on your will, and you don't want your brother-in-law to raise your children. Okay. Let's close the poll. So I briefly went over it earlier, talking about healthcare proxies, but here is the whole package that we do when we have a will package. We create new wills for you and your spouse. We create 2 general powers of attorney, which are your financial powers of attorney, one for you and your spouse. We create 2 medical powers of attorney, one for you and your spouse. That's the healthcare power of attorney. And then we also review your beneficiary designations to make sure that they're in line with what you tell us you want for your estate plan. And to accomplish all of that, we have 2 meetings. We have a design meeting and a signing meeting. And in between, we have lots of phone calls and emails. So we're always available for you. And so the pertinent question, everybody asked this, what's it going to cost me? So we want to make this as affordable for young families as possible. So we've decided that we should do a payment plan. The usual cost of a package like this, 2 wills, 2 general powers of attorney, 2 healthcare powers of attorney, and review of beneficiary designations, that can be as much as $2,000. But for those of you who took advantage of our webinar, we're offering this complete package for $1,200. It's $1,200. But we're offering it on a payment plan. You can pay monthly at just $100 a month for 12 months. Let me take a look and see if there's any more questions. I don't see, let's see here. We did have one question come in. Do you have to be married to set up wills and assets aren't 100% combined? Will that make things difficult? You do not have to be married to set up wills. In fact, it's highly recommended that you set up a will just in case. And if your finances aren't 100% combined, we deal with that most. So if you have joint assets, those are going to pass to your spouse outside of your will. They're going to pass through operation of law. So you don't have to worry about those assets that you own in your name only that aren't combined with your spouse. We can deal with those individually. A lot of assets, such as bank accounts or savings accounts, you can do what's called a transfer on death agreement, where the asset will be transferred outside of your will to whomever you like. But again, if you're a single person and you have assets, you should still set up a will in case someone that you would want to inherit from you might need a special needs trust, say a brother or a sister or a parent. If you don't have brothers and sisters and you want your parents to inherit from you, a lot of parents are planning for Medicaid, and having a special needs trust for a parent would help them with Medicaid planning. So having a will in place is always a good thing. If your finances aren't 100% combined, we can deal with that. Beneficiary designations, transfer on death agreements. Also, you can appoint those assets into a trust in your new will. And even though it might make things more complicated, it doesn't make things more difficult. There's always answers to those financial questions. So we've reached the end of our webinar. I hope you've enjoyed your time with me. I'm sorry for the difficulties in the beginning. I didn't know that my microphone wasn't on. My camera's the focus. There it is. Thank you for joining, and if you have any questions, please email us at info@robertlaw.com or give us a call. Our phone number is here on the website. I'm in the Ocean View office. That phone number is 302-537-4559, but we do have an office in Annapolis as well. That phone number is 410-266-1625. And if you want to learn more about estate planning and even trusts, please check out our website, ChesapeakeLegalCounsel.com, where we post our webinar videos. Thank you very much, and hopefully I'll be hearing from you soon.